for rebuttal?
Yes, Your Honor, 5 minutes, please.
5 minutes. And did I pronounce Murat correctly?
You did.
Okay. Thank you. With that being said, then I will allow you to begin your Whoops. You don't want to start with time already deducted. Now you may begin your presentation.
Good morning, Your Honors. Allison Murat for the appellant Anne McQueen. In our initial brief, we address a number of issues. Today, I'd like to focus on 3 main or overarching points. First, Carol Baskin is not a media defendant. However, even if she is, cure and amendment should have been permitted for the purposes of pre-suit notice. Second, the trial court's order incorrectly construes and commingles legal principles, including the fair report privilege, proximate causation, and actual malice. Third, this is not a quintessential SLAPP suit. It is not a lawsuit without merit. The defamatory statements at issue are not protected activity. To begin with the first point, the media defendant issue, Baskin does not perform the function of the traditional news media. Her primary function is not news reporting. Ross v. Gore talks about the working media, and it's the media's duty to post facts in the matter of minutes or hours. Here, Baskin is in the business of big cats, not news reporting. She is motivated by her private business interest in sharing the historical account of her life. She is an interested first-party person in this controversy, and she's mired in the dispute. In modern times, where everyone has access to the internet and can quickly publish a vlog or a blog, media defendant has to mean something more than the ability to quickly push a button. Our best cases on this point are this court's opinion in Missouri, the 5 for 5 case, Comans, and the Texas case that I cited. It's justice for janitors. I believe it's service employees. Here, Baskin reads diary entries. She relays information about her business, her interest in big cats, and events that she contends took place in the 90s. But this is not the type of news reporting that the court talks about in Missouri. Baskin has had the opportunity to curate this information over a number of years. Missouri talks about media that publishes news quickly.
Ms. Moore, I'd like your thought, because this just kind of drills right into the issue that cases that you mentioned have to grapple with, and that we have to grapple with, and the statutory language we have to grapple with, which the Florida Supreme Court and our court and other courts have held, does require that the defendant be a quote unquote media defendant. I think your brief, you've used the term press membership. Here's the problem that I think everyone recognizes, that there is not, and really never has been, anything like licensing or credentialing for media members or the press. I mean, you get a press pass from a number of different organizations, not that hard to get. Otherwise, there's really nothing to stop anybody from, hanging out a shingle, starting a blog that they feel is newsworthy. I think everybody, when you use the term media defendant, they've got in mind sort of this picture from the 1950s or 1960s of a person with a little press thing in their hat going around and asking questions and working for a main newspaper. But even then, there's always been some gray areas about this term. If you've got like a retired school teacher writing a monthly column about in a local monthly paper, I mean, is that a media defendant? I don't know. I mean, so I want to put it on you, since you're asking us to reverse here and write up an opinion. Can you give me an articulable, replicable standard for how a court can sort media defendants under Ross from non-media defendants in the year 2023?
I think that the court's decision, not this court, but the court's decision in 5 for 5 is a good start. The Daddy Yankee opinion, I believe, where the court needs to look at the type of party entitled to receive notice. Certainly, we can't dispute that a blog or a vlog may qualify as a form of news media, but you have to look at the type of party disseminating that information and the nature of the information being disseminated. You know, anyone can have access to an internet platform. There's TikTok now. There's college students posting about Rush. It would be an absurdity to extend press membership to a person that's posting about a college Rush process or a makeup tutorial that certainly, you know, may have a wide following and provoke discussion amongst people that are interested in that topic. But you have to look about, is this news information? Is this a situation where there is a person that regularly disseminates news information? That is their primary function.
And see, here's the thing, and that definition depends upon how wide or how narrow you draw the diameter of the circle around what is news, right? So, you know, your friend on the other side is going to argue that the disappearance of this gentleman and big cats and big cat rescue is news. That's an area of public interest. It may be hyper-focused. It may be on one particular area, but it is news. So how is a court supposed to, I mean, you seem to be contemplating something along, like you used, you know, the Rush kind of counter example. You seem to be contemplating a general news service, somebody that's got maybe, you know, somebody that's commenting on international affairs and domestic economy and, you know, like a traditional newspaper. But what about somebody that just focuses on, I don't know, South Pasadena City Hall issues relating to bus scheduling? Hyper-focused, but man, they are on that all the time and they're posting about that issue. Is that person not a media defendant?
It would depend on the facts of that case, and sometimes it will be difficult to discern.
But see, it's our job to let the trial courts know when those sometimes are, so that they're not just, you know,
it certainly should not be. It certainly should not be when the person is not reporting the news, but generating news, and a person that is putting out information about their own business and is involved in the dispute. This is not somebody that is reporting. This is a first person that's talking about events that purportedly took place far in the past.
So you're saying focus on the objectivity of the person doing the publication.
The objectivity and the whether or not that person's primary function is news reporting. Here, you cannot conclude that the primary function of Baskin's blog or website is news reporting. She does not perform the function of the traditional news media. If there are no other questions on that point, even if the court were to conclude that Baskin is a media defendant under a modern, broad, expansive view that would allow almost anyone to become a media defendant, then the court should have permitted the opportunity to cure and amend. Notice was sent in this case in January 2021. The second amended complaint was filed, I believe, in June of the same year. And in this instance, post-suit notice still serves a purpose. And you can look at Ross v. Gore for this. The post-suit notice followed by the amendment would provide a path to mitigate damages under the common law. It would provide the opportunity to mitigate punitive damages or stop the accrual of actual damages. And our best cases on this are Bayless, Nezelik, Ross v. Gore, and the medical malpractice cases. In the answer brief, these cases are not addressed. And this court, admittedly, in a footnote, said you cannot cure post-suit, but the court cited to a case that has since been abrogated and explained by another court that in an Orlando Sports Stadium, amendment was not permitted after there were 5 purported amendments in that case. The court
That
had
wasn't what that was turned on, was it, Ms. Barnett? It didn't turn, I mean, there were 5 amendments in that case, but what it turned on was the notion that the cause of the action doesn't accrue until the post-suit notice is complied with, correct?
I'm having a little trouble hearing your audio. It's breaking up just a little bit. But I heard the part about cause of action not accruing until notice is sent. I would say if you look at the language of the statute, it does require that notice be sent prior to filing the lawsuit, but it is not a jurisdictional condition precedent when you look at the language of the statute. And if you analyze the statute to the medical malpractice cases, the same result should be reached. This should not be a jurisdictional issue. It should not be a subject matter jurisdiction issue. And the statute of limitations had not run in this case when notice was sent. The second point, and this is an overarching point in our brief, is that the court's order conflates and incorrectly construes legal principles and issues of law. The most evident is in the fair report analysis, but it carries over into the other issues as well. There's a distinction between the fair report and fair comment privilege. The fair report privilege belongs to the news media or someone performing the function of the news media. It's a supervisory reporting role to report on official proceedings. Fair comment belongs to anyone commenting on a public issue, and it pertains to matters of opinion. And in the court's order, the court talks about the fair report privilege, but then cites cases talking about the fair comment privilege. And that's where the confusion starts. Additionally, even if we're talking about fair report privilege, it is not a first party protection. There is no privilege to self-report. And that's what's happening here. You have the party that made the statements coming back and contending that they're simply reporting what happened in a court proceeding. And the law doesn't allow for that. The second issue is that this is not, even if it could apply, this is not accurate reporting. There's an abridgment of information. And you can look at the Dershowitz case from the Southern District on that point. In that case, CNN ran a clip and they only showed maybe 2 minutes of the clip, not the whole clip. So there was a gap of information. In this case, we have Carol Baskin saying, well, I provided hyperlinks to the court docket, and so I'm reporting on what happened. It's an accurate report. But this is a 1997 case. You click on that link, it takes you to a court docket, not documents that you can discern what happened. And it also, she omits key information that there was an apology letter and there was a settlement pertaining to libel and slander claims. And those are crucial facts that Baskin says McQueen embezzled money by transferring properties to her own name, and the court ordered her to return those properties. But that's not what happened. There was a libel and slander claim, there was a settlement, there was a payment of money. So there's an abridgment of information that takes this outside the fair report privilege. The second issue that the court confuses is proximate causation. The court points to the existence of other publications to say Baskin's publications cannot be the but-for cause of damages in this case. But that analysis does not align with the multiple publication rule, which can be found in the, I believe it's Musto case, where with each new publication, there's a new cause of action and a new injury. There's a new audience that may be reached. There's no single inference that should be gleaned from this, that Baskin's publications are not the but-for cause of McQueen's injury. And that's from the Zimmerman case, which Baskin relied upon, but that is also a circuit court case. And it doesn't talk about the multiple publication rule or the different audiences that may be reached, the wider reach that Baskin has after Tiger King.
I need to let you know you're at 15.
Yes, Your Honor, then I will save the remainder of my time for rebuttal.
Okay, thank you, counsel. Mr. Vogt, it shows muted on your speaker. Otherwise, you are able to proceed with your presentation, counsel.
Thank you, Your Honor. May it please the court, Shane Vogt on behalf of Carol Baskin. And I'll start with the judgment itself in this case, which the judge actually, went far and beyond the call of duty by completing a thorough analysis of 59 alleged defamatory statements in this case, all of the videos and articles in which those statements appeared, and all of the circumstances surrounding the publications at issue, which he was required to do under the law. And as a result of that, we have a 23-page order containing detailed factual findings that the appellant does not contest, and the well-reasoned application of the law to those facts. And the appellant has not demonstrated any sufficient grounds, factually, legally, or procedurally, to reverse that final judgment.
Well, Mr. Vogt, I mean, the appellant wasn't permitted to take discovery of the defendant. So wouldn't it be a little hard for them to come up with evidence to rebut the summary judgment evidence?
It would not, and I'll explain why. The trial court's analysis in this case goes through several issues, the vast majority of which are decided based on the content of the publications themselves. That includes the actionability of the statements. It includes the public figure status of the plaintiff. It includes whether or not notice was sent pre-suit under section 770.01. It includes whether or not the articles are protected by the fair report privilege. It includes the proximate causation issue. These are all issues that this trial judge—
How does the court even get to causation when you haven't even had a chance to figure out what the damages are or take any discovery? I mean, you think maybe that was a little bit too far out over the skis, so to speak?
I don't. I understand, Judge Lucas, where you're coming from, because typically at proximate causation, I know there's case law saying that it's a fact issue. But you have a decision right on point here in the Zimmerman case, where because of the level of statements that were made about the plaintiff publicly that he wasn't suing over, and that were made by other people and in other publications, there was no way for the damages at issue in that case to be caused by the defendant's alleged statements. And the strongest example that we have of that is on page 7 of our answer brief. We actually included a screenshot because one of the big statements that the plaintiff likes to focus on is this supposed allegation about embezzlement. Well, she herself appeared in a interview on YouTube with Jack the Ripper on April 10th of 2023, which is at the time and preceding, quite frankly, the defamatory statements over which she sued. And the pleadings that we're talking about in this case that contain references to this supposed embezzlement appear on the screen with her. That's precisely the type of situation that the court was dealing with in Zimmerman, which was affirmed on appeal, albeit PCA'd. in the trial judge, and I think this is important, doesn't just rely on Zimmerman. She cites it in a footnote, but she actually notes all of the cases that require as an element of the plaintiff's claim that they have to establish that the statements at issue proximately caused damages. Those facts, by the way, are exclusively within the plaintiff's control. All of the facts that they needed to provide to the court to meet their burden under Gundel, the plaintiff should have known and never made any effort to file in this proceeding, as the judge recognized, as the plaintiff failed to comply with the requirements of 1.510 with respect to the
Can
summary
you-
judgment aspect.
But can maybe let's move past the causation issue for just a moment. You started off with the argument that these statements just aren't even actionable. I mean, forget the media defense issue for a moment. Help me through that. What is your understanding of what constitutes an actionable statement under current Florida defamation action?
So under current Florida defamation action, in order to establish a claim, there are two elements that I'll say with respect to the content of the statements that have to be established. Number one, the statement has to be provably false. And number two, the statement has to be defamatory. And it's in the context of those requirements that courts are required to look at the content and the context of the publication as a whole. And that's Florida law as applying United States Supreme Court precedent. It's why it was important that the trial court went through all of the videos and all of the articles.
So here's the thing. In our review of the trial courts going over those statements, as a matter of law, if a statement is defamatory, would we give any deference to that decision? Or is this de novo? I mean, since we're looking at the same evidence that she looked at, can we come to our own conclusions? And I'll tie that in. Here's just one example that candidly had me scratching my head a little bit. This was in you all's, or it was in the 52 summary statements that was provided to the court in the context of the summary judgment motion. We have here what's purported to be one of the vlog quotes where your client says, "I have gone easy on her," meaning Ms. McQueen, "because I have not been sure how much of her transferring was done as theft and how much Don may have known about, but for her to step in and lie about something that we both know the truth about, and her attempt to destroy my original documents by sneaking them out of the office in a box of her tax papers. I can see no reason to protect her any longer. Can she be arrested for embezzling? And can your firm represent me in the ensuing lawsuit? The proof is overwhelming." Help me out. How do we get to that being non-defamatory?
Okay, so I'll answer your initial question first, is which it is de novo
Sure.
review.
Okay.
Because whether or not something is defamatory is determined as a matter of law based on the statements as a whole. The reason I brought up initially the fact that you have to look at the content and context as a whole is because the particular statement that you were just referring to was a statement that was in her vlog. All of those vlog entries are read from diary entries. And what the trial court did in this instance in analyzing those diary entries, and it found correctly under the law, was that in reading those statements, Carol Baskin wasn't making affirmative factual statements. What she was doing was reading a historical recollection of her mental impressions from her diaries at the time that those events occurred. And she made that.
That sounds an awful lot like an intent state of mind kind of determination that would be wholly inappropriate in summary judgment.
Well, in this case, it's when you're talking about intent, which is different than the issue of whether or not a statement is defamatory. And so when I clarify that, is she's telling readers at the outset with respect to this blog, these are my diary entries from dates well in the past. This is what they say. She's not affirmatively stating to readers, these things are true. This is what I believe now. This is what happened. she's going through the process of reading these diary entries to her actual viewers or readers, people following the blog.
But she's not saying like this is a working fiction manuscript. She's saying these are my diary entries. I mean, an ordinary listener would perceive that to be, oh, one writes factual events and impressions on factual events in one's diary. Wouldn't the ordinary listener, ordinary hearer perceive that to be statements of recorded fact?
No,
That's how I would view it.
I don't. And the trial court actually in its order referred to some of the case law that we cited. This is it in the record in the order at page 2016. Throughout the vlog entries, defendant read from what she stated were written historical diary entries. To the common viewer, it's clear that defendant was expressing her own mental impressions, opinions, or commentary, or simply recounting her past perception of events as they unfolded decades ago and then brought back to life in recent time. And then cites several cases that support the arguments we made in that regard. One of which is this Obsidian Finance Group case, which specifically held, and it's a District of Oregon case, but obviously whether or not something is defamatory or not, that law is consistent pretty much throughout the country because federal constitutional principles apply. But in the Obsidian case, the court said where statements read like a journal or diary entry revealing feelings or stream of consciousness, statements are protected by the First Amendment as opinion and are not actionable. Because essentially what the publisher is doing in that instance is telling the viewer what their perception of events were at that time. It is inherently by nature an opinion or a statement of what one believes, and opinions are not actionable under constitutional principles. I can't hear Judge Lucas.
Matt, you're muted.
Thank you. So I was going to say, but it seems to me by the lights of the characterization you just made, you could never use a diary to refresh a witness's recollection on anything because a diary, after all, is just nothing but opinion, mental impressions.
If I'm remembering, and from law school, I had Professor Everhart, and what he said is you can refresh someone's recollection with a pumpkin pie if you want to. If there's anything that can refresh their recollection, then that works. So I think those are incomparable situations.
Okay.
And if you don't have any more questions on that issue, I'll sort of try to go back and address some of the arguments that have been made so far on the Section 770 issue and whether or not Carol Baskin qualifies as a media defendant. And I just wanted to point out a couple of things. And again, Judge Lucas, you asked a lot of these questions, but I think one of the things you indicated is that it's your job to let the trial court know, what kind of defines whether or not someone is a media defendant. And you've already done that. You did it in Mazur. And in Mazur, what this court said was that the traditional function of the news media is defined as someone who uses the publication at issue to, quote, initiate uninhibited, robust, and wide open debate on public issues. That's specifically what the trial judge in this instance found. And she found that based on facts that are not refuted. But
help me out, because the ultimate conclusion in Mazur was that I think it was Penguin Random House was not a media defendant. I mean, if one of the big 5 publishers didn't qualify as a media defendant, how does this vlog?
I'll explain it, and there's 2 ways. Number one, it's a book publisher, and the other defendant in that case made movies. Those
Right.
That's the temporal requirement that we're talking about, and that it comes into play in 2 ways. Number one is that they publish quickly But more importantly, Mazur just discusses the fact that they're capable of retracting quickly. So when you have someone who operates a website such as Carol Baskin or a vlog, she has the ability to retract or correct quickly. You can't do that with a book or with a movie. You can't reach out to the people who have seen that thing and tell them, hey, come back to the movie theater so we can show you the retraction or correction on this.
I mean, I take it, you can pull a book, but I mean, I take your point about it's not the same kind of retraction.
Right. And so there's two components of that temporal requirement on how quick the media is published and capable of being retracted that I think are important. The other thing is that the trial court made findings which really distinguish this case from Mazur and some of the other ones that have been talked about here. Those findings included that, number one, Baskin's not a mere internet using private individual. This is in the record at 2012. She owns and controls both the vlog and website where she regularly posts information. And that to me is important because this isn't just someone sort of posting something on Facebook or Instagram or what have you. The trial court actually analyzed the website materials and the vlog itself, and you can see they go back 10 years and they cover a variety of topics. And in fact, the topics they cover is what Mazur recognizes when it cites the Commons, you know, when they say even medium operated by a single individual or small group of people that are primarily an informational purpose, most commonly in an area of special knowledge, interest, or expertise. That's precisely what Carol Baskin's vlog and website are. If you look, there's a ton of information on them, primarily about big cat issues and the advocacy that she engaged in on behalf of big cats and trying to get rid of private zoos. That's important because, yes.
Mr. Vogt, let me interrupt you, and I apologize, but I got a message that my internet connection is unstable, and I want to ask you this question.
Okay.
It seems to me like you contradicted yourself. On the one hand, you said, these are not actionable because these are just her recollection of her impressions, you know, from 20, 30 years ago. On the other hand, she is a media defendant because she is trying to generate robust discussion over a matter of public importance. Those to me seem to be inconsistent with each other. So which one is she?
She's both, because you can generate robust debate amongst the public, whether you post strict factual information, opinions, or commentary. In fact, that was addressed in Mazur. Mazur specifically notes that media defendants include people who editorialize, is the word they use. And in the Commons case, which Mazur relied upon, it determined that media defendants include those who provide comment and criticism, such as an editorial writer.
But you editorialize about fact. And so the editorializing is not, oh, I'm editorializing that she's that she's an embezzler because these facts have been established. I mean, what she's saying is, in my stream of consciousness or whatever, I thought these were the facts, that she, falsely notarized this document, that she embezzled the $600,000, that she walked out of the office with papers. I think that confuses the editorializing with the facts.
And I don't think that you have to post or publish strict facts in order to initiate robust or widespread debate. That in itself is not a requirement under the statute. And I'll give you a good example. Tucker Carlson, Fox News, CNN, no one would dispute that those entities qualify as media defendants. And for the most part, every single thing you hear on those shows at night is opinion and commentary. And I would argue very little fact. And they defend cases by saying
that's up for debate. I mean, people make that complaint, and then other people say no, they're paragons of objectivity, and we're not going to settle that here.
Right, but that's why that you sort of made my
But
point.
at least they very clearly hold themselves out to be media companies that are delivering news, right? Not reading diary entries.
Right, but this statute in particular does not require anyone to hold themselves out as a news organization. That's why it has been held to apply to vloggers and bloggers. And I think it really is important to note sort of the factual distinctions between the cases where people have been found to be media defendants and those where they have not. And the appellant cited a couple of these, but the Commons case, the Plant Food Systems versus Ivy case, the Tobinic case, those are all where there were vloggers or individuals that were putting out materials that address topics of interest. Publications where notice was not required, Ortega, Trujillo, the Five for Entertainment, and the Zelenka case were things where you had press releases being issued, one-time press releases.
You're at about 19:30, so if there's something else you want to get to, you have about 30 seconds left. I want to make sure you did.
Okay, thank you, Aaron. I guess the only other thing I would point out for the court is that in order to prevail in this appeal, I know we've talked about 770 and a couple of the other issues, but the plaintiff would have to convince you to reverse on every single one of the grounds that the trial court relied on to dismiss and grant judgment in this case, because every single one of those grounds independently warrants a judgment in favor of Carol Baskin. Be it actual malice, fair report, the notice requirement of the statute, the actionability of the statements, and the appellant simply has not overcome all of those grounds that the trial court so eloquently put in its order. And for that reason, we would ask that this judgment be affirmed. Thank you.
Thank you, Cal. Attorney Morit, we are ready for your rebuttal. You have your 5 minutes remaining, counsel.
Yes, Your Honor. Quick points I would like to make. My opposing counsel talks about the court's comprehensive order and analysis of these 59 statements. Typically, when you see these orders on defamatory statements, the statements are broken down individually, and the court goes through and tells you why something is opinion versus fact. This order does not do that. It lumps all the statements together to say that they are matters of opinion. If the court has the opportunity, I'd like you to look at the record at 1562. It's a very short transcript of a vlog, and it's purely factual. It talks about how there was a closing on 600 acres that Baskin forced Don Lewis into buying. He got mad at her and sold the property to somebody else. And Ann McQueen forged Baskin's name on the closing documents, and then she notarized it. There's nothing within that vlog that could be construed as hyperbole, rhetorical, or opinion. This is a historical account, false statements of fact subject to objective verification and empirical proof with depositions, handwriting analysis. This is not opinion. These are not opinion statements. The disclaimers on these vlogs really mean nothing. That's from the Dershowitz case. Simply couching something as opinion or entertainment does not dispel a false statement of fact. You have to look at what was said. The Jack the Ripper article or interview that was referenced, the court should have that video on, it was sent to the court, I believe, on a CD or a thumb drive. Baskin says that McQueen addressed the embezzlement charges in this video. I watched the video. That's not what happened. Potentially, McQueen agreed to an interview. The person doing the interview put something up on the computer screen. It's not shown to McQueen, and she doesn't discuss the nature of the statement at all, other than to say that Don Lewis didn't have 6 secretaries. There's no discussion about the embezzlement claims. To touch on actual malice, the court ruled that the apology was too remote in time, but the court implicitly confused actual malice with express malice. Actual malice is about knowledge. Express malice is about motive and intent, where you can't have evidence that is too remote in time to show the intent to injure someone. Actual malice is just about knowledge that a statement is false or with reckless disregard. The apology statement in this case should have been enough to get to a jury, especially when you're talking about something that's subjective and where no depositions were afforded. The Mazur case, Mazur, supports McQueen's position, not Baskin. It cites to Ross. It's more than provoking discussion. It's about the speedy news reporting function of the media. In the federal cases that are relied upon by Baskin, stop short in the analysis. Their analysis, they're not binding on this court. If you look at them, the courts focus more on the nature of the internet platform, the blog, whether it's accessible. But like we talked about in the beginning, the court needs to drill down into whether this is the type of party that's entitled to media notice and the nature of the information being conveyed to the public. If the court doesn't have any other questions, I'll conclude with saying that every person clearly has a right to voice their opinion, and you can put that opinion on the internet, but no person has the right to defame another person, to ruin their career or their livelihood. And the court's ruling in this case abridges the plaintiff's right to seek redress in the courts for damages, and instead requires her to litigate this dispute in the court of public opinion on the internet, and that's not the law. We ask the court to reverse.
Thank you, counsel. Thank you both very much. You are now free to return to the other landing spot, so to speak, and that will conclude this day's oral argument. And I will see the panel members in a few moments. Thank you all. We are in recess.
Thank you.